All right, everyone. Welcome to day 3 at Lead Generation World. We've got a great day planned for you. We've got 3 excellent sessions lined up, and we're going to be kicking off the first one here in just a second. But I do want to make sure I go through my normal housekeeping items, which really there's just one, and it's to participate. We've got excellent presenters today, and the best way to get the most out of what they're going to be presenting on is to ask some questions. So if there's anything that comes top of mind that you'd like to get more detail on, you can do it one of 2 ways. You can type in, if you're using the Whova app, you can use the Q&A section to the right. And go ahead and type your questions in there and I'll see them. If you're watching this on Zoom, you can use the Q&A function there as well and type them in, and we'll see them there as well. So we'll see them wherever you put the questions. We'll see them and we'll answer them at the end of the presentation. But again, I definitely want to encourage you to ask questions. Okay, that's my only housekeeping item. Let's go ahead and get started. We've got Rebecca Stopford from Bhayani. She'll have to correct me if I said that wrong. But she's from Bhayani HR Employment Law, and she's going to be talking about all things regulations, which is a really important session that we always plan for our conferences, because it's important that you understand what legal risks that you may be taking and or want to avoid while doing lead gen or digital marketing activities. So without further ado, Rebecca, I will go ahead and hand it over to you, and you can correct me on how I pronounce the your company name, and let you take it from here.
Okay.
Thank you.
Don't know why. Oh,
yeah, no
sorry.
problem.
Yeah,
There
we
you
go. Hi everyone, welcome to this compliance session, and it is Bhayani Law. It is an HR and employment law practice, but I pick up the non-HR and employment law bits that come to those lawyers. So it's a very varied practice that I have. I am a solicitor qualified in the UK, been qualified since 1997, so we're getting proud of those credentials now. And so I am going to be concentrating on UK law. I don't close my eyes to the EU and US aspects, but this is really about what I know more about, being data protection in the UK. Why is it? Michael, it's not, might need to reshare. Oh, there we go. Sorry, panicking here. I will get the hang of it. Oh, we're just starting a big thunderstorm here outside, so hopefully that's not going to cause any problems. I've had a bit of a varied career, and that's allowed me to be able to give quite generalist commercial advice, being not a big firm lawyer. And it's important to, well, I feel it's important just to kind of explain my background. I really like working to get results and not quoting section numbers at people. So it's more about principles, application, practical steps. And I've learned that through working in a niche IT law practice around 2000, so that was interesting. Working in high street firms, being mainly the only commercial lead there. And I've also worked in-house in a global manufacturing company near Manchester, where they made tape and wound care products, so nothing to do with data, but with global aspects. And there were just the 2 of us working for the whole world aspects. And it's just sold for millions of pounds in the last couple of weeks, that company, which is interesting to follow. And then I've been a consultant with a company called The Legal Director, providing flexible in-house legal services for a variety of portfolio clients. And now, again, as a consultant with this small outfit in Sheffield, keeping most of my old clients and working with new ones daily. So These words on the screen should be a refreshment to you for what we all were working to coming up to the 25th of May 2018. It was a big exercise for a lot of companies, and I just spent a minute just saying how it affected some and what you probably were all involved in doing at the time. It was a big move from the data protection principles before. The accountability required a lot more work, putting policies in place, checking consent, just generally owning data and being responsible for it, which was the whole ethos of GDPR. It did bring us a gold standard of data protection, and we should be proud of it. It's something that we need to keep an eye abreast of, even with the changing legal field of Brexit and things like that, but I'll address those in later slides. My clients were affected by it in different ways, and that allowed me to apply the principles in different ways and be flexible in what businesses needed. But we all get a little bit complacent thinking about data protection, GDPR. But one of the mistakes is to think that it is always just GDPR. And I'll address that later as well. We mustn't forget the electronic privacy regulations, which I know that some of your previous speakers on compliance will have dealt with in more detail, because that affects digital marketing aspects. But when we're talking data protection, I mean the whole remit of all those legislations, because you can't just deal with GDPR in isolation, even in its form post-Brexit. When I was dealing with clients, they did understand why we had to do this process. Some didn't like the fact that they were going to be getting rid of data. It gets very precious commodity, and the changes that it made to some sales processes, that they became clunky. But they largely understood that accountability was a necessary evil, and that clean data can be a great asset, and showing compliance can be a great marketing tool. So I say, how was it for you? And if the words on the screen don't ring too many bells, then perhaps I should be getting in touch. It was never going to be the end of the journey in May 2018. We all breathed a bit of a sigh of relief, and I know that after doing many compliance sessions with clients and getting them up and running, I was pretty ready for a break from it, but I knew it would come back. And yes, it has, and so it should. It should all be part of everybody's, every business's key checklist item, if whenever they're dealing with new aspects of data, new dealings with data, new compliance systems, new operational systems. There were going to be gaps in what people had done because there was a bit of a panic to get everything sorted. There weren't templates available pre-2018, so you might not be happy with your template. It's a bit of a game of poker, I felt, waiting until the GDPR day to see the big reveal on people's data protection policies. And you might have looked and thought, oh, they've got a good clause in there, or they do it better, or I've actually taken a different concept to how I've done business. And there's nothing wrong. It's good to review documents, and I'll go through a few things that you could be looking for practically in doing that renewal yourselves. We had to wait for ICO guidance, Information Commissioner Office's guidance. They were quite slow at giving us guidance. So as I say, it was a bit wait and see. But data protection is now in, there's going to be a data protection clause in most of your commercial contracts. So it's important to know what the words mean: processor, controller, is that relationship right, that it's been spelled out in the contract, or have someone got it completely wrong? Point it out. What is the limitation of liability for aspects? Which is something just not to take it as written as read, that you can accept unlimited liability in those relationships. But I also think that clean data and evidence of compliance can really matter in some other important aspects of business. If you're going to market for insurance, you may be asked to fill out a questionnaire on what you've got in place and whether you've had any breaches, even if you're not applying for data protection insurance, because that can be really expensive. Applying for new banking facilities or any kind of equity finance, they're going to want to do some due diligence and find out how you've dealt with it, because that can pose risk to their investment. Sale of business and the warranties that you might have to give as a business owner or a business buyer, well, not to give the warranties, but you want to make sure that as a buyer that the company that you're buying has got a good data protection compliance strategy in place, and they haven't just left it on the shelf since 2018. And I think it is good for attracting new clients. As I say, it's a good PR and a good marketing mechanism to show that you have got a good process in place. And also, we can now be pretty sure that the ICO's grace period is well and truly over. And I will be giving some information about journeys that people have been on when the ICO got interested in them. And it's a matter of making sure that you're on the right side of those investigations. In the old days, when the data protection was largely ignored in the lifestyle of a business, we know that new data protection regulations can pop up in so many instances. The fines were pretty low as well in the old days, and they were largely matched to the finances of the company, but that's not the case now. There can also be criminal charges. So who's checking up on you? There's been some interesting ones here. There's some vigilantes that look at policies and report people. Consumers know their rights so much more. There was so much publicity about data protection in 2018 that people do ask the question, why is so-and-so contacting me? Or why won't so-and-so stop contacting me? And then they think, I know, I'll report them to the ICO. There's a new thing I've noticed on my phone, where if a mobile call comes through that I think it's spam, you can report it to a spam function. And that's being really looked at by the Information Commissioner in whether to make investigations. And there's an interesting one about the vigilantes that you might have spotted in the news in the last couple of weeks about Rightmove. So they have a new facility to allow there to be a video of a home, and because we can't go and look around them at the moment so much, and somebody complained that the video, someone had left lots of papers on a desk that could be zoomed in on and showing personal data, and it made the news because it was suddenly Rightmove's fault that they'd allowed this video online. I think it's really the householder who should have tidied up. But it was Rightmove that got the bad publicity, that they'd allowed, they hadn't blurred out images, they'd kept images of pets, names of pets, which was asserted to be common uses of passports. It went on and on. Have a little look at the news about that. I found it quite amusing, but it just showed how far people will go to complain. And we just don't want to be on the wrong side of those complaints. There are also contract considerations for yourselves, because lead buyers will want to know that the data is clean, that the generators have collected, and lead generators will want to make sure there's a clear demarcation in the use of data once it's left their hands. There's some caution to be had about lists, because who do you go back to? You're the one sitting pretty with the data that may not have been correctly collected. And also making sure that in contracts that you know and are sure that the controller processor joint controller relationship about the shared data has been correctly recorded and understood by the parties. So this refresh that I've mentioned before, 3 years on, time for a refresh? I think so. There might be lots of things that you might want to check on to make sure that everything's looking ticky-boo. I still spot, I do read them because that's what my job. I do still spot references to the DPA 1998. And now I'll be watching out for references to GDPR and looking out for UK GDPR, which I'll refer to what that is later on. And these are just key indicators that the person behind that, the business behind that privacy policy, privacy notice, as we call them now, has not really got data protection on their to-do list, not really kept up with the game. I see references to data protection officers and data managers, doesn't matter which one, so long as it's right for your business, but they've got a nominated person and perhaps that person has left now, but they're named in policies and in public notices. I see privacy notices where I know that businesses have now changed hands, and so that the scope of the sharing within the group has changed, and that's not reflected because the businesses have concentrated on knitting the two entities together or the two businesses together, and this is still to do, but it's still in the public domain, this document, and it needs sorting out. You may have changed third-party processes that you use, and you've mentioned in privacy notices, you know, such as if you've changed your email system, if you've changed an accounting system, and in doing so, you might recall that any third-party processes, you need third-party processor agreements, and did you just sign the contract and get them up and running, or did you do the due diligence on them and update your registers about who's processing data for you? There might be new ways that you've started to use data, and whilst I think the thought processes about privacy by design will be there, did you document it in a data protection impact assessment, a DPIA? And I feel that those are really important to have in your filing system and folder for GDPR data protection, because if the ICO did want to query anything, you will be able to say, I did think about it, I might have thought about it incorrectly, but I did address it, I didn't ignore the issues, and it could help if there are problems. Are you correctly listed in the register of fee payers for the controller activities that you have? Have you grown so that you need to pay the next fee up? Or have you shrunk so that you can pay less? It's worth doing the little questionnaire available on the ICO website to work out whether you're correctly registered on that, and that they have, if you could pay by direct debit, that the details are up to date, so that you don't miss a payment, so you can save a bit of money each year if you do it by direct debit, a few pounds, that the address that they write to you, again, it feeds back to the change of the nominated person, the DPO. Do they have the right address for you to sign, because it'll be sent by email, to get in contact with you? Or are those emails from the ICO about paying up the annual fee going into someone's redundant email box? Worth a look. This is a tricky one to address. I found that a lot of businesses I work with kind of parked the retention policy for later, because there was just so much to deal with in 2018. Sometimes it wasn't clear what was required for this policy, and it was conflicting advice about how to deal with non-statutory data, you know, the stuff that you need to keep for 7 years for tax purposes. My advice was always, well, you know, you can say what you like in a retention policy, so long as you can justify the business life cycle for why you need to keep that data for a certain period of time and justify it and in a written format, and so long as you keep up to date and comply with your own retention policy. But one of the issues I found a couple of years ago was that the IT departments weren't sure what to do, how they were going to cleanse emails, how they were going to work through systems to anonymize, to delete, to permanently delete. And there was sometimes a concept, well, if I put it in archive, is that the same as deleting or moving it over? We know that that's not the case. It does mean deletion and not just storing it in some kind of little box that you can get out later. But it is really worth looking at that retention policy. Does it still work for your business? Is it something you need to add to it? Because if you're asked to do a data subject access request and you've got data for longer than you stated in your policy, then that will be picked up. So make it work for you. This is your document, you can own it. And training. There's a lot of training that went on in the early years, but it's something that needs to be done every year, and certainly for induction new starters. I've seen loads of great tools online where it can be an auditable online process. They're quite reasonable, and you can get a bundle of services and courses that you can pick and choose on a menu for your business, for staff. But it means that you can show and are accountable for the training that's been done in your business, because that's a key word, accountability. And it just makes it a cost-effective way of providing that training and showing that you kept the key staff, the people involved in data in your business, up to date. Some of the things we haven't really had to do in such great detail before. Data subject access requests, be really interesting to know how they increased. I think they did. I think people use them as a great tool to just find out, which can be a real pain to a business because they do take up time and a cost that you can't pass on. But if they're dealt with correctly, then it can be done away with, sorted out, done and dusted, and move on, and you're not in breach because you delayed or didn't comply. They can come from a wide range of people who might want to just find out things, clients, suppliers, and employees. And sometimes where to get the data from is really easy. It's just, okay, it's in that database, I've just got the name and address, off you go. But this was a big thing for me. I was working for a company where it was nothing to do with their day-to-day business, but there was a shareholder dispute and some litigation where shareholders and key founder members were facing claims from the private equity company that had financed them. And those individuals submitted data subject access requests for a period of finding out anything that was in the business about them, bearing in mind they had been directors and founder members, for 3 or 4 years worth of data in all systems. When we did the data scrape, it came up with 1 million plus documents. And I thought, how on earth are we going to redact information? And we knew that it was a litigation fishing expedition, a way around disclosure, but we were determined not to give them that information. It was just going to be dealt with as if it was a data subject access request, where we just give them information about themselves. So the redaction was key. We also had to make sure that we were looking through all the data to remove information that had litigation privilege. So there were software tools that we could use to narrow down the scope. There were software. I also negotiated a reduction to the scope of the data subject access request to try and get the document pulled down. But in the end, redaction, even on the software, had to be done manually to check for the litigation privilege and confidential information that wasn't relevant to the subject access request. And it did cost that client upward of £70,000 in time. And so it was considerable. But it needed to be done, even though we knew that it wasn't potentially done for the right reasons. And as I say, the classic problem is this reveals data that you shouldn't have because of the retention policy. I know that you wouldn't, but don't get busy deleting things. It's tempting, but don't. And also, sometimes it can bring up unsupported legacy databases and consideration of what people might hold as their own data in their own systems that hasn't been taken into account in your data mapping. I think a common example of that is in the recruitment process, where CVs for applicants can be given to lead managers to look at, and they can then be saved. But on your data map, it will just show that they're held by the HR department. So it can highlight where data flows to and is held that you've not documented for retention, for description, but also for complying with a subject access request. Hopefully haven't had any breaches, but they can be small. They could be really on the edge of, is this a breach, or is this just something that we don't really need to address? I think the ICO have been quite good on this in giving us guidance on what is a breach and what is not. And the ICO, the government website, the ICO section, really is the best place to go for information on most things, data protection. It's up to date as much as it can be. And it does give guidance on what to do if there's a breach. They don't want everything reported. And that's what people had to do at the beginning, though, because we were waiting for this guidance. There's really a risk assessment to assess what is the adverse effect on the individuals. But even if you choose not to report it, you've got to document that breach so that, yeah, if someone then complained, you have got a document accountability process of the steps that you reasonably took to manage that breach. And then address any holes that caused it. Sometimes, and usually, it is human error, and that goes back to the training aspect. We can't help pressing the wrong email button. We try not to, but it happens. But there are things that can be so easily managed, like spreadsheets with salaries on to be password protected. All those things that you know about. It's just reminding and checking and making sure that complacency doesn't steep in. I find it's really important that in a business that there is ownership of these issues, and even if you've not got a data protection officer, that there is a data manager who is the key person for everyone who've got a query about data protection in the business. And if they don't know the answer, that they have resource to a third party to ask, who can give them some guidance, because they may not have all the skills and they may be a bit scared of taking on that role. But it does mean that someone is owning the tasks. We can take into account the independence that that person should have in the considerations of who it should be. And in smaller businesses, sometimes there does have to be a bit of blurring of those lines. But if it's jointly held, fine. But if it's group done, I just don't think that there's the core understanding and ownership of the tasks. So getting to a bit more technicality here after those general reminders. Where are we? So the privacy and e-commerce regulations sit alongside GDPR and shouldn't be forgotten. There's most of the complaints that come to the Information Commissioner are about breaches of the e-commerce regulations rather than other data protection rules. It's still marketing that causes the problems, and now we're going to be seeing more on cookies. The ICO haven't yet done a swoop on looking at websites and cookies, but I feel it's coming. And it is a good time now to keep abreast of what the guidance they give about cookies. It's quite technical, and you need to have explicit consent for non-essential cookies. So it does require some interplay between IT teams and making sure the policies are in place. But those fines, while smaller, can still be crippling for a business. And it all comes out at the bottom line. So it wasn't good news for some, and apologies for anyone who knows this business or is involved in it. I did check that they're not a member, but it's out there in the public domain, and that's where a complaint or a finding of the ICO will be. That website, that web link that I give, gives reports about what they've done and what action has been taken recently. And I having a little look. This is the top of the list, March 2021, and it relates to sending marketing texts. The facts are a little bit complicated, but this business was fined £250,000. Quite substantial. It was out without any link to its actual financial strength. I have had a little look at Companies House. They don't seem to have this kind of money, looking at their accounts. It really came to a crunch because they just bombarded individuals with texts, and people complained. But it seems, as a quick précis of quite a lengthy report on that website, that they had collected this data from a third party who hadn't given the lead, the contact, the individual, all the correct information about who their data would be shared with, or allowed them the chance to opt out, or even tick a box to opt in, that they wanted this information. And there was no obvious way for that person, once they started getting information from the third party who gathered the information, to opt out later. And the ICO felt that the individual would not expect to have heard from LeadsWorks because they weren't part of the documentation available when the third party gathered the data. Everything's decided on its facts, and it's just, so it's giving a few takeaways that are good, but you know, the ICO will apply the rules about e-commerce regulations and data protection on the facts of a particular case when they're making their judgment. A few things that we can consider: that consent was not freely given because the individual had to tick at least one person that the collector could send data to before they could go further. So that removes the freely given aspect. They felt that LeadsWorks didn't check that this consent had been given in the correct manner and was compliant with GDPR and PECA. They felt that as LeadsWorks was a fee payer, it knew its responsibilities because it was paying as a controller, so it was alive to these factors, and therefore negligence was a factor. It didn't stop doing it after the ICO had started the investigation, and they held themselves up as the text coming from Avon, who had nothing to do with this. It was some kind of frolic of LeadsWorks' own to do the text from Avon, which I haven't got to the bottom of why, but that's what they did. And the takeaways, and you may find some for yourself if you want to look at the whole judgment, is just be careful with lists. Check the source, check how it was collected, do your due diligence, ask questions. And once you decide to use that data, make sure those decisions are recorded in a data protection impact assessment. If you get unsubscribes and opt-outs, act on them, because that's the one way that consumers get irritated, that they're getting things again and again, and it causes them to reach out and make a complaint. Funnily enough, as you'll you may be aware that details of unsubscribes and opt-outs can be kept without limitation of time. So they, even though someone has said, I don't want anything from you, you should keep that list with that forever, really, so that you don't then inadvertently send them data again, which I find quite an anomaly, but that's how it goes. Stop as soon as the ICO gets in touch. And yeah, the fine hit the bottom line. It was, and in your instance, in your business, who would pay? In here, it was the lead generator, but it could be another party who faces the impact from the ICO. More examples, another fine under e-commerce regulations, just 50,000 here. But again, they sent lots of emails. They hadn't got links on their website to privacy notices and no means to opt out at the time, because they would be relying on the soft opt-in for that purpose. And later correspondence and emails didn't have the opt-out button. So again, it's another small company that the ICO got interested in enough to fine them. Some other things that have happened, another company made lots of calls to individuals who had opted out on the telephone preference service, £72,000 fine. Another company had there was a breach, so one of the very rare ones that's actually due to GDPR. So interestingly, an employee in the motor industry was passing on details of clients who brought the cars in because they had an accident, passed on the details to an accident claims management company. There was a fine for the firm, probably had nothing to do with it. The individual got a custodial sentence, had to pay some costs, and any benefit that they made from passing on the data was confiscated under the Proceeds of Crime Act. Don't think I'd like to have been on the end of much of that. And then the small one here, but still leads to getting your business on the ICO's radar, is not paying your fee. Like I say, that can be inadvertent just because those emails are going to the wrong place. But the fine can be up to £4,000, so that's a bit of a pain. The big businesses would make the news, but as we can see from these examples, the ICO is not just going after the big companies now. It does like to make an example of them, and it will probably not be shy about putting the information out in the press. But you know, small ones are being loaded onto their enforcement notice site as well. Okay, so just check the time. Brexit and GDPR. I've ignored it till now in this talk, but we must address it. So we're okay at the moment. There's a bridge in place, the trade deal bridge, until the 30th of June. I don't know, this is a bit conceptual because it may not affect your business if you are not receiving data from the EU, and this is where the aspects happen, but just to keep you aware of it in case it becomes an aspect for your business. But due to Brexit and the changes in laws, then the EU GDPR is converted to something called the UK GDPR, which sits alongside the Data Protection Act 2018. Fine. It's business as usual with what a controller is, what a processor is. Article 26 of the GDPR is still Article 26, but it's got a new name. But it does have an impact in transfers, cross-border transfers. With this bridge, everything's fine. But we're waiting for an adequacy decision from the EU Commission to deem that the UK provides an essentially equivalent level of data protection to that in the EU for EU data to pass to the UK. Like I say, it may not be a consideration for your business if if you're dealing mainly in the UK or solely in the UK, but there may be aspects where it does apply. We do think that there's going to be a positive adequacy decision. So EU businesses, EU branches of your own business will feel comfortable in sending the data of EU citizens, residents to the UK, because we will not, although we're a third country now, because of Brexit, the adequacy rules mean that we've been deemed to be okay still. Which so we should be. We've got the DPA 2018. We're doing essentially the same thing, but we just need an adequacy decision to make that absolutely correct. We're not in control of that. It's coming from the EU Commission. It may happen before the bridge ends, or it may be delayed, or it might not come. So we need to think about what would happen then. If there is a negative adequacy decision, unlikely, but you never know, or a no decision before the end of this bridging period, then a business will have to take steps and be ready to act to make sure that the receipt of data from if they're in EU, if data is flowing from the EU to the UK, is still okay. And that can be a relationship between a client, or as I say, between an EU branch of your own business sending data back to the UK. And it can be done with standard contract clauses and a manual assessment of risks and safeguards. If this applies to you, then it's something to think about and get to know about in a bit more detail, but just so that it's raising a point to you now. And how does this affect you? It's when you go back to your data mapping that you did and have kept up to date with as to where data flows, and even looking at the cross-border issues in that data mapping rather than just between file A and file B and who it's shared with. And it's worth noting that the adequacy decision is revised by the EU Commission every 4 years, so this could be revisited. At the moment, we've only just left, so yes, everything's still okay, but as time creeps on, might we have different laws in place that mean that the EU Commission are not happy with adequacy? So it's just worth keeping an eye on those kind of aspects as well. Quick word about the USA and sending UK data or EU data to the USA. It's again a little bit technical, but we've had policies in place and processes that have helped us to do that in the past. Unfortunately, holes have been found in them and have been kicked out. So we've had Safe Harbour, Privacy Shield, to name a few. And we're in a little bit of in-between land at the moment as to what is a valid way of sending data from the EU and the UK to the US. And that's still being considered at the moment. So if this involves you, then I'm sure that you've been thinking about this and making sure that you've got standard contract clauses in place, risk assessment, and other safeguards. Again, if this applies to your business, then and you weren't aware of it, take a look. And if you were aware of it, just make sure that you keep an eye on how the news changes on this. Last but not least, just a few practical, I know it's a crowded slide, so apologies for that. Practicalities of what this means. Get terminology right, update references to GDPR to UK GDPR, something simple, or perhaps something more generic like data protection regulations and requirements or laws. You don't even have to define what they are, you can just say all applicable data protection laws, but if you want to go the whole hog, then there's an example below as to what that does mean in the UK at the moment. Again, that's the only time I've really quoted a few acts at you. Remove references to EU law, EU membership, EU territories, because I do see references in policies to the number of EU countries and things like that. So again, it's got less relevance now. Review data mapping, put your DPIAs in place with regard to data processing over borders, and just keep abreast of these things. because it's moving, keeps moving, and who knows where we will get to on a few of those points we mentioned in the last few slides. So what mark would you give yourself? 10 out of 10, or could do better? I think so long as you have some processes in place, that's great. If you feel that there's some holes, then hopefully during the course of this talk, you made a few notes as to where you want to apply your resources, and good luck to keeping a gold mark standard for your business.
All right. Perfect, Rebecca. I do have, we just got just a minute here left, so I can't go through all these, but I do have just one question. It was around, is ICO, have you had noticed whether the ICO has been more active or less active over sort of the last 12 months through the pandemic? I had a conversation with them a few weeks ago, actually maybe it was a month ago, and they had mentioned they're actually building out a specific team to focus on the lead generation industry. So
there we go.
Yeah. So I don't know if you've been able to, tell whether how, their activity level or not, but that's one question I thought would be interesting to hear, and then we'll have to wrap it up.
Okay, they do have little concentration periods on different sectors, and that is something useful to hear if they are going to be concentrating on a sector. I would say that when I last looked at the enforcement section, I'd say 6 months ago, it was all about taxi firms.
Yeah.
So I do think that they home in on a certain area, and I feel that they have staffed up, because I've even got a nice spelling mistake on my own website, but yeah, anyway. They have staffed up. I know at the beginning you would be pretty clear not to, nothing would happen for ages because they just didn't have enough caseworkers, but I think they've got more resources. So yeah, I think things are happening quicker, and you can tell when you look at the Leeds Works example, that only happened last year, and now they've got the fine already in March. So yeah,
moving quickly.
Yeah.
Okay, good.
Yeah.
Well, thank you for that. Yeah, and for those that have any other questions, you can email Rebecca to her email as shown, and then obviously, as she mentioned, the website is missing an N, an I there, but I think you'll catch that.